Well, hello, and welcome back to another episode on the 0%. For those of you who have been talking about the accord and satisfaction process, and some of you have success and others are still trying, and I understand. You go back and forth and you're trying to figure out why isn't this working? Avery, this isn't working. It doesn't work. We need to have support. It's as much support that I try to give you. You have two options. You can do it yourself, pro se, because these things lead to court, or you can go ahead and get an attorney. But however, if you get an attorney, you will limit yourself. It depends on the amount. It depends on what type of property you were trying to discharge. And on top of that, we already know that attorneys are trying to put a turn on you, which means if you need representation, everything that you've done, including your evidence that you give to the attorney to help you win your case, is simply not enough. So I do understand your sentiments when you tell me that going the attorney route to support you in your accord and satisfaction isn't working. I always see that no matter what, even if you do this by yourself, and if the case is dismissed and you didn't get remedy, well, you might have learned something within that, and now you can go back and refile and do it again and make that correction. I like to set it up to where I don't have to go to court, but I'm prepared to go. And as you see here on the screen, Stellantis Financial Services is one of my loan servicers for an auto loan. If you guys remember way back, I think it was the second quarter of this year, maybe the first quarter, maybe last year. So I talked about I wanted to go get a Tesla. It was nice. I had it for a while. And I gave you the plans of what I wanted to do. I wanted to do a special endorsement when I sign at the dealership and be able to enforce it and get paid exactly what the value of the car is. In fact, the value of the loan plus the finance charges. Didn't really get a chance to see that through. Why? Because the car just wasn't a good car. Okay, nothing against Tesla product. I just think they have a little bit more to go. They have a little bit ways to go, but it's cool technology, extremely cool technology. I think the Model X that I had was the coolest car that I've ever driven. Super fast. It's a lot of fun, but I couldn't really enjoy it. I was always in a loaner, always in a rental that they gave me because they were working on it. So I said, forget it. Let me go ahead and trade this in while I can. So I traded it in and went and got a Ram truck. I needed something to tow. And so got the fastest one that they could because I just liked that. And it served me well. So I decided what I'm going to do with the Ram is operate and initiate the accord and satisfaction process in Florida. So here on the screen, you see the mail that I received here. This is this year, 2024. I know it's kind of blurry there using the Pitney Bowes red stamp over there, but it is 2024. And as you see, it says JP Morgan Chase. So what I want to do first, before we get into my process from beginning to end, I want to start from the end. This is going to be a little bit of a freebie for those who are not a part of the course, who have not seen any of the case laws or descriptions or anything. They have no idea what accord and satisfaction is. Okay, and I want to kind of tell you where you're going to take it as far as how to enforce what you're doing in the end, because this takes care of personal loans, auto loans, mortgages, credit cards, but only if you want to close the credit card indefinitely. But if you don't want to close your credit card, I wouldn't do it. This will pay your premiums on auto insurance. You can do an accord of satisfaction on premiums for your auto insurance, but still keep it open. What else? Title loan insurance. All of those things can be utilized. It's included in the accord and satisfaction process. So what I'm going to share with you is my letter of intent to sue, and use it if you like, but I would recommend that you would tailor it a little bit different. Do not copy word for word. That doesn't do anybody good in this space, because believe it or not, when they receive these types of letters, they are going to put it on the bulletin. That's the best way I'd like to explain it, and send it out to all the corporations and say, look out. If you get this, pause. Here's the other remedy that we may have to stop you. So the reason why they do that is because they do not like to see other people doing a process for them where you get paid and then you give the person who did it for you a piece of the pie. They do not like that to happen. They would rather you know how to defend yourself, you know how to write your own documents, you know what you're doing, and therefore you get all of the remedy. And that's why I have this remedy here. I know what I'm doing. I know how to flip it. I know how to change up my tactics depending on what they do. So let's open up the letter that I used, and I tell you guys that the newspaper is where you want to go first. I tell you that the newspaper is your best friend, okay? You want to utilize this for every single thing you do as a warning to someone before you sue them. I've utilized Heritage Florida Jewish newspaper, and they published this in Seminole County. You can do this for all of your trustee minutes. Every single thing. If you have issues going into the county and they won't record your documents, they won't record your trust, well, how about you take your declaration of trust or your memorandum of trust, whatever you called it, and put it in the paper? Why? Because it is still considered to be a recorded document within the county. And you know how important it is to start at the county. So please try your county first. Don't be afraid of the clerks, even though they say they've been there for years and years and years and act like they know everything. They don't. But try first. And if they don't, find you a local newspaper in your county or county of choice. Okay, it doesn't have to be your local county where you live. It could be any county in any state, any country of the continental United States of America. All right. So this was done back in May of 2024. And let's read. It says here, this is a public notice of intent to sue. Okay. Regarding breach of accord and satisfaction agreement. Now, I will show you the check. I will show you the initial contract in getting the transfer from the Tesla over to the TRX, the Ram truck, and the refund check, okay? And you also need to take a look at what supports this accord and satisfaction, which is the Florida State Constitution. All right, the date is May 14, 2024. I want you guys to pay attention to this text over here. Hopefully you can see it. I'll zoom in a little bit more. It says to Stellantis Financial Services Incorporated. And just so you know, before we read it, if you look at the contract here, you'll see at the bottom here, that Stellantis was the financial institution that took over the responsibility of collecting the 75-month term, the payment of $12.97.93 per month. All right. So let us go down to the actual section. I sent this to the compliance department. It says this letter serves as a formal notice of intent to sue regarding your breach of the accord and satisfaction agreement we entered into on October 13, 2023, concerning account number, and you put the account number. The background. On October 13, 2023, Stellantis Financial Services Incorporated reached an agreement to settle a bona fide debt related to my account. The terms of the agreement stipulated that Section 673.3111, and that is basically UCC 3-311, applies when the claim is unliquidated. That means I did not report this account under a bankruptcy or insolvency proceeding. So it is unliquidated. Uncertain amount or disputed in good faith by the debtor. This statute allows using a writing on a check like payment in full. You can say full satisfaction of claim. You can say accord and satisfaction, whatever you want, just something to that delineation. As evidence of accord and satisfaction if certain conditions are met. In good faith, I fulfilled my obligations under the agreement by disputing the debt administratively and notifying your office. Such checks or drafts will be submitted for less than the original agreement. No answer or correspondence was received, and therefore several checks, drafts were submitted and cashed. Now, here is the breach of agreement section. Stellantis Financial Services Incorporated has failed to uphold its obligations under the accord and satisfaction agreement under the rules of Florida by knowingly accepting each check or draft with clear and conspicuous restrictive endorsement on the face of the checks or drafts. Specifically, check number 626 in the amount of $1,500, dated 10/13/23. And as you see, I go all the way down and list all of those checks, and you keep a copy of them. Section 725.05 of Florida statutes disallows using a notation on a check for less the full amount as evidence of accord and satisfaction. However, this account is in regard to a dispute in good faith, barring Stellantis Financial Services from suing for the remaining balance. The breach of agreement has occurred by continuously reporting a balance to official credit reporting agencies, affecting debt-to-income ratio after the first acceptance and cashing of check number 626. Stellantis Financial Services opportunity to refund the check number 626 lapsed on January 12th, 2024. That is a 90-day refund period per Florida statute. And that 90-day rule is inside of the Florida 673.31111. You'll find that in UCC 3-11. This breach has caused significant harm, such as financial losses and credit reporting hardships. Now I'm really throwing it on them pretty thick right now, right? Boo-hoo me. Now, here's the demand for resolution section. I demand that Stellantis Financial Services immediately remedy this breach by reporting the account as paid in full to all credit reporting agencies and refunding every payment received after October 13, 2023. As of May 14, 2024, the total refundable balance is $17,367.09. Here is the intent to sue. If I do not receive a satisfactory response within 30 business days from the date of this local publication, confirming that Stellantis Financial Services will take the necessary steps to fulfill its obligations under the Accord and Satisfaction Agreement, I will be forced to pursue legal action to enforce the agreement and seek compensation for the damages I have incurred. I am confident that we can resolve this matter. However, I am prepared to take all necessary legal steps to protect my rights. Please contact me at the phone number or address listed above or on the account file to discuss this matter further. And this is the actual newspaper publication number. As you know, they did not contact me. They didn't do anything. All they've decided to do is send me a check. And the title is on the way and the account is zero. Okay, so let's take a look at the check. We see here that it's drawn off of JP Morgan Chase Bank as of September 18th. And today is September 29th, 2024. Now, what do you see wrong with this picture? We see here that there is no description. We see that the invoice number is ending in OVRPMT, which is overpayment. So they're stating that I overpaid by $8,862.46. According to my calculations, there is a $17,000 refund that I'm expecting, and then the rest of it needs to go to zero. So there's a difference here that I'm going to have to enforce, but this is a win. Because if you were to go into court and let's say you asked for the $17,000 plus the actual certificate of title, meaning the balance goes to zero, sometimes they'll come back in mediations and say, well, we're not going to give you the $17,000. In fact, we'll just go ahead and give you $8,000 in your certificate of title. And now if you're in court and that happens, I would say, take it, run away with that deal, because you've walked away with a lot of equity. In my case, since I'm not in court, I'm going to write a simple letter saying, hey, you need to recheck your accounting. You're short about $10,000, $9,000. And if they give it to me, great. If they don't, still great. I have the certificate of title in hand. What do I care? Because now I'm going to take it from my name and it's going directly into the trust, either the trust enterprise or the express trust. And that's perfect setup when it comes to insurance and all of that. So that way I can utilize more comfortably the private IDs that we've talked about. So that's the letter. Now I want to get into the Constitution, because that is very important that we all know that. Depending on the state that you're in, you need to know your Constitution and why it's so important to utilize the newspaper. And you've heard me say this before, but it doesn't hurt to have a refresher. In the Declaration of Rights, Article 1, Section 4 speaks on the freedom of speech and press. The press is the newspaper. So it says here, every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. So companies are doing this, and you have to do this, all right? And the newspaper is something that you want to take advantage of. If you utilize the newspaper to publish your sentiments and to give a fair warning, that's what you call a caveat. Caveats are used for estate planning. When someone is about to pass away, you want to let the courts and everybody else know, including all the creditors, that there is a trust in place to protect this person's assets, so that way things can be distributed without a problem. That is a warning. It means let him beware. So when you use the press and you publish things such as the letter that I just talked about here, you are avoiding one of those decisions that a judge will tell you in court, well, you didn't give them fair warning. And to be honest with you, I believe that the newspaper warning is much stronger than the administrative procedure, where you send something once, second, and third. With the newspaper, you do it once, and because it is circulating on a weekly basis, then you've already fulfilled that first, second, and third. And this is why I tell you, take each one of your trustee minutes, no matter what it is, your declaration of nationality, anything that you have in there, birth announcements, you're getting married, put them in your trustee minutes, put them in the paper. And now, because the document is going to be notarized, for you to make this turn this document into an actual legally, I'm not going to say legally, but lawful binding document that can be used in the USA or out of the USA, you can now take this to the Secretary of State of Florida, get it authenticated for Taiwan, Sri Lanka, whatever non-Hague Convention country that is out there. Once you receive it, then take it to the final step at the United States Department of State and get the gold seal. You see how that works? Now this becomes the record of evidence in your court case instead of on the record. There's a difference between on the record and evidence. All right. So in continuing this, it says no law shall be passed to restrain or abridge the liberty of speech or of the press. So no matter how many times they talk about it in social media that they're going to censor people, it's never going to be done. Sure, they'll make it difficult for us to make, digital coin on the side via YouTube and all of that. But there's ways around it, and there will always be a private black market. If the matter charged as defamatory is true and was published with good motives, the party shall be acquitted or exonerated. All right, so you need to use the paper. And since I use the paper, I actually did exactly what corporations do. They use the newspaper every quarter to report their earnings, their debts, their liabilities, their liquidity. They do it every quarter because the National Banking Act says they must do it, and it has to be sent off to the comptroller. So They do that because you're supposed to know how that bank is truly doing as far as stock if you're going to invest with them. And that has to be public information. So everything you want to do, you want to be upright, you want to be formal before you take anybody to court, and the newspaper is the best way. Okay, so let's take a look at the actual contract for a second, and you'll see right here in the trade-in section, it talks about the Tesla here, Model X. There was positive equity, of course, and rolled that over. And so now ending balance was about 61,000 that those payments were going towards Stellantis Financial Services. Now that there is no lien holder on this Ram truck, it's going to go directly into the certificate of trust. I'm sorry, the trust. And in my case, what I'm going to do for this one, it's going to go directly into the trust enterprise, because I won't keep it for a long time. I know that I'm going to sell it or trade it. So it just makes it easier to have monies go into the proper private bank account that is already open under the trust enterprise. All right, so the next thing I'm going to show you, and then that'll be it. If you guys recall from the junior course, when you did your specific UCC3 termination against that specific agriculture lien, well, I'm going to show you how you continue that, how you continuously add additional debtors to that lien. And you can guess right now, Stellantis was one of those debtors that needed to be added. Why? Because I'm assigning the debt to them. The remaining debt that is after the first accord and satisfaction payoff has to be assigned to them. It's no longer to me. 12 USC 411. These are the obligations of the United States. And since this document here, where'd it go? Yes, the contract here, because my signature is on it and social somewhere in one of these documents, and I rarely use that thing, but I wanted to do this process to show you guys currently that this works. That's why I went and did it. I didn't need a car, but I did it so you can see how accord and satisfaction works, and you can do it for your current assets. But if you recall, going back to the UCC3 termination, you have to add Stellantis or whoever your loan servicer is, whoever it is that you're trying to discharge. You need to add it to that document to show, okay, all of that difference has to be assigned to them in order for the discharge to make sense, because documents like this is considered an obligation of the United States due to the bankruptcy that took place almost 100 years ago. So 100 years ago, sorry, 1933, around that time. All right, so I have to stop it here for those that are not privy to the actual course to see the next part of that. But if this is something that you want to do, you can do it. It's a simple step-by-step procedure. All right, you want to start off by doing your bona fide dispute letter. And then, of course, they're most likely not going to answer it. And then you just make your simple payments that you do every month using a special restrictive endorsement. I show you how to do that on the actual check or money order. Send that in. There's a special way you sign it on the front and the back. And if they still stamp the back of the check and deposit it, that is a countersign. Okay? They have countersigned an actual lawful document for negotiation. They're greedy. Banks are greedy. They don't think that you're going to sue them. But if you put all the ducks in a row, and they know if we go to court, we absolutely have no wiggle room. We have no way out of this. He is going to win. She is going to win. Do exactly like your peer, Tanya. She did it and continuously doing it. So, and there's others who've done it within the, forgive me if I missed your name, but you have to do it step by step. So when you do that, you're going to get you will get a remedy for sure. All right. So I think this is a great remedy. Look, we have an asset here that worth about $110,000, paid $17,000, and balance of about 57 is discharged. I say that's a pretty good spread, right? Now, please don't use this type of thing to try and, oh, well, I'm going to go sell it and cash out. But why? People, if you do this, you need your car. So keep it. Be thankful for what happened and keep it. You don't need to turn this into some kind of side hustle or business. That's not what this is about. If you have the intentions of doing that, I think the universe is going to not allow it to work for you. My humble opinion. And I also want to mention one thing about 1099 no IDs. You've heard about people online, YouTube, talking about if you take a 1099 no ID, take the information off of the car, vehicle sticker, put it on there, and send it into the dealer. They'll give you a car thinking that, well, this is money that's going to come to them later. You have no idea what you're talking about if you're saying that to people. You have to really know what OID is, original issue discount. That is for bonds. Okay, that's for bonds. Let's say this bond here, this contract here, it says face value of $61,929.56. Now, we didn't factor in the finance charge, right? Whatever finance interest rate they gave me, you take that finance charge times the 75 months and you get the full. So that means that if I were to pay this over a term of 75 months, I wouldn't pay $61,000. I'd pay a lot more. Let's just say that number is, for this example, $130,000 total, principal and interest. All right. And let's say Stellantis Financial Services, they say, hey, you know what? We don't want to stick around and wait for him to pay us $131 over 75 months. Let's go ahead and add this to our other ones that we have, thousands of them, package it, give it a rating based on everybody's credit scores, and sell them off to other investors. And that's what they do. So now that $130,000 turned into, let's say, a $1 million package. Okay, so now they're going to sell it to an investor. They're going to sell it for a little less than $1 million. Let's say they sell it for $800,000. So now they're still collecting and they're turning that payment over to the investor. They've already been paid $800,000. They took a little discount on the principal and the finance charge. So that means Stellantis does not have the right to file original issue discount because they've actually made a gain. The only way you can have original issue discount is if this balance here, 61,000, or let's say the sticker price of your car, you give that up, you surrender it to someone else for less than this. $61,000. So if I surrendered it to someone else for $50,000, the difference between 61 and 50,000 is 11,000. That's the original issue discount. That is the interest that you just made. And the IRS expects you to report that interest on your taxes. So you can see already the myths going out the door with 1099 no ID. Now you see why those who did it had the IRS knocking on their door and incarcerating them in federal prison. They followed a method and wanted the money quickly, and they didn't know how to, protect themselves. They didn't know what they were doing. And if you do anything like that, the government actually sees you to be highly proficient in knowing what a dollar bill is and knowing how to use it. But they didn't know. So please read the instructions that are on these forms. It's right there. It tells you what it's for. You can't do that. Okay? So with that being said, I'll stop it right here. For those who are watching on the public platforms, if you want to see the rest of this and to show you about the UCC3s and what goes on there, please come in to www.the0percent.org, and then we'll continue and you'll see the rest.